Welcome to the Estate Made Simple podcast with Jenna Carbello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to another episode of Estates Made Simple. We have a very interesting topic today and an exciting presenter with Nicole Garton. But as we jump into that, I just want to remind our audience that our purpose or why we have this podcast is to share timely information regarding estate administration for executors and administrators. And one of the things that can create a lot of stress and concern and a newfound issue that personal representatives to deal with is digital assets. So that's what we're going to talk about today. And welcome Nicole Garton to the podcast. We're delighted that you could make time in your busy calendar to share your thoughts with our audience on this important topic.
Thank you so much for having me.
So let's first, share a little bit of information, Nicole, about yourself, and then we can talk into maybe that first question of when we say digital assets, what does that mean?
Thank you. So I've been a lawyer for around 25 years, the last 20 primarily wills and estates. My current role is I'm president of a BC regulated trust company called Heritage Trust, and we act as professional executor, power of attorney, and trustee for BC resident clients.
Yes, and I think a unique qualification that I think it's only happened a couple of times, if memory serves me, from a presentation, Jenna, you did recently, that there's only a few people who've done what you've done. So a bit of a trailblazer in terms of a lawyer starting or a law firm starting a trust company, but an interesting venture into this space, but makes a lot of sense. I think you identified a strong need for that and are looking to fill that need for the residents of BC. So congratulations on that.
Oh, thank you.
So tell us about digital assets, because that's one of those phrases that could mean different things to different people. So what do you understand by that phrase, digital asset? Intro the subject matter for us.
So we throw that word around a lot, but it generally encompasses some main categories, which would be your social media profiles. So your Facebook account, your LinkedIn account, it'd include your email accounts, online banking and investment platforms, not the underlying assets themselves, but the portal into which you can view those assets, cryptocurrencies and non-fungible tokens or NFTs. That's one of the sort of hot things people like to talk about. And things like cloud-based intellectual property, like photos or digital manuscripts. Those are generally what encompasses digital assets. And they usually have specific terms of service as part of signing up, which we call TOS agreements, terms of service agreements. And then there's an overlay of provincial and federal privacy law that will often impact people's ability to administer those assets during their lifetime and after someone passes away.
Yeah, and it's becoming more and more frequent, right? I think that's what we're seeing. I guess I'm old enough to remember a time where these things didn't even exist. That's how old I am, pre-Facebook and pre-Apple ID accounts and things like that, right? But it's the reality of a modern society, and there is no abating the pace at which we see the growth in this area. I guess that's the other introductory comment is I don't see this slowing down, and people are getting more and more familiar with it, and they're going to go, yeah, I had a meeting today and we have a clause in their will about cryptocurrency. The very first will I drafted when I started practice did not even have that as a consideration. So that reflects the times, but executors need to deal with this. So let's jump into the topic of considerations for, like, how does this relate to executors? Jenna, maybe lead us off in starting the conversation regarding the details of that.
Absolutely. And Nicole, I'm sure you've seen so many different types and amounts of digital assets through your practice as a lawyer and also as the head of a trust company. So I'm curious, what is your first tip that you tell executors when they're dealing with an estate, or perhaps people that are planning for their own estate when it comes to digital assets?
I think proactive planning is incredibly important because these assets are just part of our daily lives and actually can have really significant value. So they may have economic value, but they often can have incredible personal value. People's photos, writing, communications can often be very important to family members. So it's important that you put some thought into it. For practitioners, like people that are advising people engaging in estate planning, it's important to have those conversations with people now and get them thinking about what they want to do with those assets and make sure that they're providing some thought into what they do want to have available. So they may want their loved ones or beneficiaries to have access, or they may not. There's a privacy overlay. And so it's important that they give consent and informed consent. Maybe I'll just talk about the privacy legislation in Canada. We've got something called PAPI. You'll hear that often. It's the Personal Information Protection and Electronic Documents Act. That applies to the private sector and federal business works and undertakings, except BC and Alberta actually have their own legislation, which is called the Personal Information Protection Act. And then, of course, Quebec likes to be unique, and so they have their own act as well. So there's an overlay of privacy legislation that impacts these assets. And so to be a knowledgeable and effective practitioner, it's important that you understand not just the underlying digital assets themselves, but the regulatory overlay that impacts them.
And I suppose part of that understanding is creating a list of what one has when it comes to digital assets and inventory for the executor and for our family members so that they know where these assets reside and exist. What would be included on that inventory?
So if you're going to create that's part of best practices, is coming up with an inventory of what your valuable assets are and to give your executors access. One of the interesting things is people think, oh, I'm going to potentially share my password. That unfortunately is not so straightforward, because using someone else's password almost always contravenes the terms of service agreement, or they call the click wrap agreement, that probably not many people read. But whenever you sign up for Facebook or Apple or Google or whatever custodian of those digital assets, you are entering into an agreement, and it's almost always a breach of that agreement to allow third parties to use your password. A lot of these services have memorialization options. So for Apple, Google, Meta, LinkedIn, they all have a mechanism where you can assign if you became incapable or passed away, you can assign a individual who has the ability to legally access your account. So not only doing an inventory, but thinking about who actually will have the legal authority to access your account. The other thing to think about is including a digital assets clause in your will. And if you're engaging in multiple will planning, like maybe you're doing probate fee avoidance in British Columbia, quite often we have a will for corporate assets and a will for personal assets. The personal asset will often gets probated. If you're going to have a digital assets clause, you should have it in your personal will that's going to be probated, because quite often the custodial owners of these assets, they do require a court order. And so it's good to have the probated will to have the digital assets. So yeah, an inventory is best practice, but you need to think beyond just that and providing passwords. You need to give people proactive access and make sure you've given them requisite authority inside a hopefully probated will. You can also provide proactive consents for your personal representatives to access these digital assets. Keep in mind, though, that a lot of these companies aren't necessarily adhering to those. And there's been a fair amount of case law where even when people had Canadian court orders allowing people to access, for example, a Facebook account or Gmail, Google and or Meta actually didn't adhere to that court order until they got one in the state of California. So it's not as straightforward as just a list. You've got to really be thinking proactively about what is valuable, what do you or maybe you do not want people to have access to, and then how are you going to effectively facilitate access after your incapacity or death.
And that's one of the changes that I notice in talking to practitioners is more and more they're asking, do we want to include this? But particularly on the estate administration side, I know in Alberta, through the surrogate digital process of going through probate, in the portal there's actually a portion where you can put in some reference to digital assets or what the reference those authorities. So there may be an opportunity even through the probate process to obtain appropriate authorization. I guess what you're saying is it might work, but it might not, because you may have to replicate that in the state of California or wherever they're headquartered. Okay, so that's good to know, is obviously needing to figure out which applicable law. I guess the point being is that some of that can happen ahead of time and some planning for that, just being aware of it. And it starts with the executor even knowing what's out there. So Jenna, to your earlier comment about how are they even going to figure out all these things? It starts with an inventory, having a list of this is what I have. And even with things, I know particularly with currency, I think it's super important to have that password, right? From what I've heard, I haven't dealt with it yet on an estate administration side, but having that key, if you will, that password for that crypto is all important. And it's not like there's a workaround solution. You either have it or you don't.
So that's a good question, or a good point with respect to crypto. That is, I would say, the exception to the rule of not sharing passwords, because access to that key is pretty fundamental in terms of crypto. So if you don't have that key, it's almost impossible to access those assets. And we have at Heritage Trust, unfortunately, a few people have passed away that owned crypto, and we unfortunately do not have access to the key. And I can tell you how incredibly onerous it is to try to access those assets in the absence of that. We're negotiating with a wallet company to try to get access, but that is definitely, if you've got valuable crypto, it is critical that you have a secure place for that key, and that you give that key to your personal representative so they can liquidate or transfer those assets.
The other thing I think I like about what you're saying is also providing direction, right? While you might appoint somebody with specific knowledge about those currencies or those assets to deal with them, like NFTs, it's also clear to have your instructions. What are they to do with those? It would be important to let your wishes know, or the executor is faced with, what do I do with this? What is going on? Can be, as you've just highlighted, a real struggle.
Quite a famous Canadian case people probably read about in the news was the Quadra CX matter. That was Gerald Cotton, who was the young man who passed away suddenly in India, I believe. Unfortunately, passed away with the key to, I think, hundreds of millions of dollars worth of crypto. His widow, my understanding is that they were unable to locate the key, but his widow, I understand, was able to obtain a court order to access his Gmail account from a Santa Clara, California court. There was attempts to try to find the key through the Gmail account. So just to give you a sense that if you don't do proactive planning and you have valuable digital assets, what you're creating is unfortunately an extremely complex legal and regulatory environment where your beneficiaries are going to be subject to a very expensive and multi-year legal exercise to try to get access to those assets. So if you do have valuable assets, it might be crypto, it might be NFTs, or maybe just very important sentimental things like photos, manuscript, whatever it is, it's critical that you do some proactive planning and meet with practitioners who have some expertise in this. And as our society continues to evolve and we continue to live online, I think this is only going to increase exponentially. And our experience at Heritage Trust, where older people that were generally more paper-based, if they've passed away and they weren't that organized, we were able to find most of their assets because they were paper-based. We redirected their mail. They had a paper address book. And generally speaking, we're able to find the most critical assets. Unfortunately, we've had a couple of people that have passed away in their 50s that had significant tech and or crypto assets, and that has been very onerous in terms of trying to access and secure those assets for the beneficiaries. As a result of that, I think we've chatted about this. We actually came up with a product which we call the Canadian Estate Organizer, and the idea is to walk people through creating an inventory or a list of what your estate wishes are, and in the context of that, what your important digital assets are, and giving your personal representatives access to that to make sure that you're preserving that valuable asset if something happens to you.
And that could be in line with a password manager. I know you've written about password managers in the past. Have you seen people using that in practice, and has it worked well in terms
Yeah.
of gaining access to the accounts? I know there's legality around actually using those passwords, but having that list of all the online accounts, the trigger
Yeah.
clause of when the passwords are shared with the executor, has that been useful and helpful in practice?
So again, I think the problem with the password manager is because we would be breaching all the terms of service by accessing those passwords. So what I would say to listeners, I'll give people sort of some tips. So I think the first thing is a post-death account management tool. Facebook and Instagram have their memorial system. LinkedIn has a memorial system. Google has an inactive account manager, and Apple has a digital legacy feature. And so I think step number one is a lot of people have, I think this is the case for me too, like very valuable family photos, for example, on Facebook. So utilize that first and foremost, because then that person has clear authority. The next thing you can think about is there's something called an independent digital asset administration service. So these are companies where you can actually purchase a digital vault, and there's crypto specific services. There's something called dead man switch technology, where sort of macabre sounding, but if there's been inactivity after a certain period of time, it actually switches to a subsequent owner. There's backup features of hardware wallets, and you also get insurance from hackers and human error. So particularly if you've got really valuable crypto, definitely look into these digital asset administration services. And then the other thing you should be thinking about, I think we talked about, is a digital assets clause in your will, and particularly the will that's going to be probated. And you should consider providing a positive consent for the purposes of privacy legislation for anything that you specifically want disclosed, provided that you're comfortable with that. You could provide a direction to close, gift, and or liquidate digital assets. No guarantee that the custodian is going to adhere to that, but at least you've documented your intention, which could help with the subsequent court order. The other thing that could simplify things is you could consider corporate ownership of valuable digital assets. For example, maybe your company URL is owned by you personally on GoDaddy, for example. If you've got a valuable web domain, for example, a good idea is to actually transfer that to corporate ownership. And that is much easier to administer than if it was held personally. You could think about uses of trusts owning those assets, although there's a dearth of Canadian jurisprudence on trusts. And then I think that final thing we talked about was password sharing. So it may seem practical, as we've talked about, it almost always violates the terms of service, which could lead into account termination or repercussion. You're increasing chances that the passwords could be compromised every time they're shared. Your passwords, they get outdated very quickly because they get amended. There could be various different passwords for different custodians, which makes it difficult to manage. But again, always share the key to crypto, because that is pretty much the only way to access the crypto assets, for i.e. private keys for crypto held in what we call cold storage. If you're an estate planner, never accept any password information, because you're just exposing yourself to liability. So the thing about an inventory is, even if you're not providing your password, it's good for what we call digital hygiene, because if you're creating a detailed list of all your valuable digital assets, it allows you to delete unnecessary accounts, which is good for security. You can check and update and make sure your passwords are secure. You can make sure multi-factor authorization is enabled. So that means that there's 2 levels of access to prevent hackers. That inventory can be helpful for estate trustees. If you have particularly valuable assets, like maybe you're an author or a noted photographer, or you've got some really cool, valuable NFTs or something like that, you could think about whether a digital executor is appropriate, where you could appoint somebody. Quite often we've heard of literary executors or artistic executors, where people have died with very valuable cultural assets, and often they'll have a will and an executor that just pertains to those very particular assets, and they'll appoint a subject matter expert for those assets to make sure that somebody sophisticated is able to administer them.
The other thought, Nicole, maybe you can comment on an agency basis, if executors find themselves into an estate and realize they may have gone in over their head because there's all these complex assets, including the digital assets we're talking about today. Can they reach out to a company like Heritage Trust or other trust companies that might have experience in this area to say, can you help me through this? Do you find you're getting retained for dealing with that aspect of the estate administration on an agency basis?
Often we are. So an agency basis is you can hire a professional executor for some or all of an estate to help you. So sometimes it's people that are busy. Sometimes it's with complexity or conflict. So when you have professional executors, we generally step in when there is significant conflict and or a significant complexity or issues. And the thing about a professional is the benefits are we have the sophistication and experience. We have continuity. The downside, though, is of course you have to pay a fee to have a professional executor, and it's not as personal, perhaps, as a family member, particularly if you're dealing with really sensitive communications. So you've got to weigh the pros and cons for your own situation and then make the best decision for your family. But if there is a lot of complexity or risk, certainly consulting and or retaining a corporate executor could be a way to deal with thorny issues. And keep in mind, like being an executor is pretty thankless. Like we have what we call that fiduciary duty, which in lay terms means we have to do a good job and act in the best interests of the estate, but that if you don't administer things correctly, unfortunately, you can be held accountable for damages and loss. So if you're experiencing a lot of complexity or uncertainty around these issues, I think what I would do right away is make sure you get really good legal advice first and foremost with somebody who's got expertise in this area, and then from there try to make the best decisions possible to make sure you're not unknowingly adversely impacting those estate assets.
Yeah, and I guess, that really gets to the point of the complexity of the assets can drive the planning, but also if you find yourself in that situation, seek out those experts to help you through so you're making good decisions, because it's not an answer to say, I didn't know what to do. Right?
I think those are some great tips, Nicole. And as we close off, I thought if I can put you in the hot seat for you to share an interesting story or maybe a surprising story that you've experienced in your role as a lawyer or as a trust company leader when you're dealing with digital assets.
We have an estate currently where this gentleman had 6 figures of crypto and we currently cannot find the key. So that is a thing to avoid because that's a substantial asset that's otherwise not available to his beneficiaries. So if you do nothing else, make sure you've got digital wallets set up and you've appointed a successor owner of those wallets so you're not throwing away stuff. And then the other thing I would say is with photos and really valuable things like that, just put some thought to it because don't underestimate how important those assets are to your family members. So I know there's been a fair amount of litigation with health authorities and universities where people have passed away unexpectedly and bereaved family members have been seeking to get clarity into people's sort of final days and trying to get access to email accounts and things like that. And they end up in a complex maze of privacy and interjurisdictional law. So if put some thought to it, do you want your family to see your medical records? Do you want them to see your private communications? Maybe you don't. So put some thought to that and document what those wishes are, and it will save a lot of potential expense and delay for your family members if something happens.
Thank you so much, Nicole. We appreciate your expertise and your time today. How do people get a hold of you if they want to reach out to you?
Thank you. You can reach us at heritagetrustcompany.ca. And even if people just want to chat, we are happy to chat anytime. And also we have a blog on our website, and we actually have some posts on digital assets and best practices. So you can just check out our blog posts, and we have a checklist that people can use to get themselves organized.
I
And for our
appreciate.
listeners, sorry, Gord, to interrupt you, but for our listeners today, Nicole also, she didn't mention, she also has her own podcast. So if you didn't get enough education from Gord and I, where to find more estate-related education, which is always fascinating and interesting to think about.
Thank you,
just
Jenna. I appreciate the shout out.
Yeah, it's a real good quality podcast. We're admirers of that. I think the more people talking in this space, the better. So kudos on that and continue that work. And we'll put links in the show notes to your company website and some of these other services, including that digital inventory you spoke of. We'll make that available for people so they can judge whether that's appropriate for them. But some excellent tips in a very complex area. And we probably have only scratched the surface. And so I want to thank you for helping us with this. I'm sure we may have you back for another episode or round 2 on this topic or others. So thank you for joining the podcast for us and sharing your wealth of information, Nicole.
Thank you, Gordon and Jenna.